The next case to come before the court this morning is State of Ohio versus Tyler Williams. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal if you are the appellant and wish to reserve any time. If you let me know when you get started, I'm keeping track of the clock and kind of can help you pace when you get into your rebuttal time. We have read the briefs. Please do not use the names of any victims or minors as we are live streaming this oral argument, and it also will be posted on the court's YouTube channels. We are ready to proceed when you are.
Good morning, Your Honors. Lindsay Poprocki of the Lorain County Prosecutor's Office on behalf of the state, who is the appellant in this matter. I would like to reserve 3 minutes for rebuttal, if I may. And this is the state's appeal of the trial court's decision to grant appellee Tyler Williams motion to dismiss the indictment under RC 2941.401. And that revised code section addresses the speedy trial rights of individuals who are incarcerated in Ohio prisons and requires incarcerated defendants to complete several steps to receive its benefit. If a defendant complies with those requirements, the state must bring him to trial within 180 days of the notice that the defendant wishes to proceed on an untried indictment. To trigger the state's burden, though, a defendant must cause a written notice of availability to be delivered to the prosecuting attorney and the appropriate court in which the matter is pending. The statute directs that the notice by the prisoner to the warden have in custody of him, who shall forward it to the appropriate prosecuting attorney and the court. This court has stated that the statute is not ambiguous. Consequently, this court's role is to apply the statute as written and not to interpret it. Here, there is absolutely no evidence in the record to support that a notice of availability was ever sent and or received by the Lorain County prosecuting attorney and or the Lorain County clerk of courts. Despite that lack of evidence in the record, Williams will contend that he started the necessary process under the statute by submitting a written notice to the warden, who then failed it to send it or forward it on to the state or the court. Under those circumstances, William argues, and the trial court agreed, that he sufficiently complied with the statute because any error in the ultimate service of that notice should not be imputed to an inmate such as himself. Thus, the issue here is straightforward for this court. Did Williams' alleged efforts under the statute satisfy the code so as to flip the trigger and start the speedy trial clock? The state submits that his efforts did not satisfy the statute. This court has unequivocally stated that it requires strict compliance with the terms of RC 2941.401. In doing so, this court explicitly held in State v. McGowan that the 180-day time limit under the statute does not begin to run until the prisoner's written request is actually received by both the prosecutor and the appropriate court. This court was explicit that if a defendant fails to serve both the prosecuting attorney and the court, the state's duty under the statute is not triggered. In McGowan, the facts are important in McGowan. In that case, it was uncontested that the defendant submitted a written notice to the warden. That was shown because the prosecutor was served with the paperwork. However, the appropriate court was not served with the defendant's written notice and request for final disposition. This court was clear because the defendant did not demonstrate that he served the appropriate court with his written notice. He never flipped the switch, and at no time were his statutory speedy trial rights activated. This court explicitly held that contrary to defendant's assertions, submission of his written notice to the warden did not satisfy the requirements of the code.
Counsel, I just want to make sure I understand. There was a hearing here, right?
There was.
I'm sorry, and he testified?
There were two hearings, I believe. At first, there was just an oral hearing where arguments were made. And then the court called a second hearing where there was an evidentiary hearing where the defendant testified.
And so I guess what I'm wondering is, if the court heard him testify and evaluated that he was credible, why doesn't that just stop the inquiry, basically? And that he had made service on the warden.
We're looking at the precedent under the 9th District in McGowan, where McGowan stands for the proposition that is not enough. Service on the warden is not enough. We're aware of the fact that the trial court relied on the 8th District Court case of Gill, which the defendant will argue that compliance with service on the warden is sufficient, but we would argue that that is not sufficient under this court's precedent.
Thank you.
And that is exactly our position, that the defendant relied on the 8th District Court case of State v. Gill, and the trial court agreed with that analysis. However, this court's precedent is clear that speedy trial time does not begin to run until both the prosecutor and the court are served with written notice from the defendant, irrespective of what the defendant sent the warden. And even under Gill, there must be evidence that the inmate has properly completed and forwarded all necessary information and documents to the warden for processing as prescribed by the statute. We would submit that even under Gill, which requires evidence that the forms were properly completed, this court is being asked to rely on assertions that were not confirmed by the record. It is undisputed that neither the Lorain County Prosecutor's Office nor the appropriate court ever received Williams' request for final disposition. This is in contrast to both McGowan and Gill, where at least one entity received the notice which provided evidence of its existence and the warden's receipt. The state would submit that in granting Williams' motion to dismiss, the trial court erred when it relied on Gill to conclude that Williams strictly complied with his statutory duties under RC 2941.401. Contrary to the trial court's conclusion, the statute imposes no duty on the state until such time as the incarcerated defendant provides the statutory notice to both the prosecutor and the court. Because Williams failed to strictly comply with the terms of the statute, his speedy trial rights were not violated. And for these reasons, the state would respectfully request that its sole assignment of error be sustained and that the trial court's decision be reversed.
Thank you, counsel.
Thank you.
Counsel for the appellee. You will need to unmute your microphone.
Okay, how are we doing now? Okay, good.
Very good, thank you.
Good morning. My name is Robert Williams. I represent Tyler Williams, no relation. It's a common name. You know, this case to me is just so patently simple. You've got an 18-year-old kid that is going to prison at LCI. And he walks in and they hand him a piece of paper that says you've been indicted on another case. You've been charged with another crime. He says, what do I do? They say, go to the law library. And this is all the testimony that was given. And if you read the transcripts, I think you have them. So he goes to the law library. They say, here, fill out this paperwork. And he fills out the paperwork. He does what he's told to do. And they say, do it. This is your notice of availability. He doesn't know the law. He doesn't know anything other than what do I do? Notify them that you're here. This is what he's told. He doesn't have a lawyer. He doesn't have anybody that's advocating for him at that point in time. He's scared to death at LCI, but he fills out the paperwork. So, and we provided documentation the best that we could. I contacted the Ohio Department of Corrections, and they sent me his file that they had down in Columbus. And what did they send to me? You have it as exhibits 1, 2, and 3. It's a letter to the sheriff saying he is here and he wants to provide notice that he may want to have a notice of availability. Whatever they sent, he had absolutely no control whatsoever what they sent to anybody. He had no control over whether or not the Lorain County Common Pleas Court clerk nor the Lorain County Common Pleas prosecutor was notified anything under the statute. How's this kid supposed to do anything, Your Honors? But he did what he was told to do. And if you look at the statute and you look at the second page of it, it says that he just has to notify the warden that he's there and that he wants to notify whomever. He did that. He complied with the basic content of that statute. And what the trial court said, and rightfully so, in its conclusion of law, when it dismissed this case, the court said when a defendant prepares a form, which he did, to advise of his availability for trial under section 2941.401 and delivers it to the prison warden, which he did because we have proof of that, because they acknowledged that in their letters, then the defendant has strictly complied with the statute's requirements that he must be brought to trial within 180 days, and the warden's failure to forward the notice to the appropriate parties cannot be imputed to the defendant. You know, Your Honors, this case probably should go to the Supreme Court because of the differing opinions between the 8th and 9th District. But based on what he did and what the Gill case says, is he just has to notify the warden, hey, let those people know that I'm here. And we have proof of that. It's in the transcripts, but his testimony, which obviously the judge heard, the judge believed he was credible. He did it not just once on the day that he arrived at the institution, but he did it 2 other times prior to him being delivered down to Richland, where he eventually ended up. So I don't know, what the courts can require him or expect him to do. He's 18 years old. He's told what to do. He doesn't have any control. How can he possibly deliver notification to the clerk of courts of Lorain County and to the Lorain County prosecutor's office his notice, his request to come and bring me back? I'm available to be. He can barely get a drink of water. So I think that whether it's incumbent upon this court or the Supreme Court or the legislature or somebody else, but do something. But this kid went in there and said, I'm here. I didn't do what I did over there. I'm here, or what he thought he was doing, but he filled out some pieces of paper, the results of which did not result in the clerk of courts or the county prosecutor receiving the documents that maybe the statute requires. But it certainly is impalatable to me that you would expect an inmate to comply with the results of the statute, which is notifying everybody else. So this case is pretty simple to me. He did the best that he could possibly do in the situation in which he found himself. And there's nothing more that we can argue here. We have proof, although limited. We certainly don't have proof, as the prosecutor indicated to the court, that it was received by the clerk of courts or it was received by the county prosecutor. But we do have proof that he filled out whatever he could possibly do when he was at the Lorain Correctional Institute. And that's the crux of this matter. Somebody's got to fix that situation. But he did what he could do. And so all we can do is say, listen, the trial court heard his testimony. The trial court believed him. And the trial court was correct, completely correct. What more can he do? Let's fix it some other way. But somebody screwed up. And if it's the warden or it's the state of Ohio or somebody, but he did what the statute requires, because the statute is very simple. It says, serve the warden. The warden shall then send it to the clerk of courts and to the prosecuting attorney. He did. We have proof that he notified through the warden that he was available, and he wanted everybody else to know. He can't send a certified letter to the clerk of courts. He's in prison. So, to me, this case is just so patently simple, blatantly simple, pardon me, that the case has to be dismissed. He did everything he can do. The law is clear, whether it's Gill or anything else. The statute says notify the warden. The warden didn't do his job. If he didn't notify the prosecutor, he didn't notify the clerk of courts. That's not our fault. So, once again, this is just a pretty simple case to me. It's interesting. It should be determined, and it should be resolved, and it should be probably better. LCI should probably change their policies to make it easier, because it's a big collection center. They should probably make it better, because what I received when I subpoenaed the records from the Department of Corrections, I gave everything that they had. And he told me he did, and he testified, and the judge believed him that he did it 3 times. And then he also testified that he went down to Richland. He asked them, listen, I haven't heard anything back about that. What can I do? And they said, you've already done that at LCI. Don't worry about it. So it's not that he wasn't conscientious. It's not that he wasn't concerned. It's not that he was trying to do what he was supposed to do, to notify. His hands are tied. His hands are tied behind his back. There's not a lot he can do. So I ask this court, I beseech this court to accept the trial judge's determination after hearing his testimony, and after believing that he's done all these things, and after looking at the statute. And the statute is clear. Notify the warden. Then the warden takes it from there. The warden is supposed to notify. If they weren't notified, that's not his problem. He's done everything he's supposed to do. If I'm passionate, I apologize. But it's not right.
Thank you, counsel, very much for your presentation today. Counsel for the state, you have 5 minutes remaining for rebuttal, should you wish to use it.
State does not dispute that Tyler Williams may have taken efforts to comply with the statute, but that is not enough here. This court has required strict compliance with the statute. The state acknowledges that the trial court applied State v. Gill out of the 8th District, which is non-binding authority on this court. This court's precedent clearly states that the speedy trial time does not begin to run until both the prosecutor and the court are served with written notice from the defendant, irrespective of what the defendant sent the warden. That is the court's precedent at this time. The trial court's reliance on the March 7th, 2019 letter from the ODRC is also concerning because that letter was sent to the Lorain County Sheriff. It was not received by the prosecutor and or the court, and merely indicates that Williams had set maybe the process in motion. It does not indicate that the process was completed or that he had officially requested a final disposition on the untried indictment. It merely indicates that the process was set in motion.
Well, I guess I'm still having some problems here in regard to the statute. When the statute says written notice and request for final disposition shall be given or sent by the prisoner to the warden or superintendent, and then the warden or superintendent shall promptly forward it to the prosecuting attorney and the court by registered or certified mail.
That is part of the statute. That's absolutely correct. I think that the state just proceeded at the hearing and in its brief on the precedent of this court in State v. McGowan, and which was then, I think, cited with approval in State v. Turner later.
Well, I guess what I'm wondering is, it seems like McGowan was a little bit different in regard to there was no proof that he had actually even provided the necessary paperwork to the warden. Whereas here, it seems like the trial court just said, I believe the defendant, I believe he did it.
I would disagree on it respectfully. In McGowan, it was uncontested that the defendant did in fact send the notice to the warden, and that was evidenced by the fact that the prosecutor in McGowan did in fact receive the notice in McGowan, but the appropriate court did not receive the notice. So clearly the notice was received by the warden, but just one of the entities did not receive the notice. So the notice was clearly sent to the warden.
Thank you.
And I think that with that, we are relying on this court's precedent. We would distinguish Gill and ask that the trial court's decision be reversed in this matter.
Thank you, counsel. Thank you both very much for your oral presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed to all parties to this appeal, as well as posted on this, Supreme Court's website.